Welcome to the next episode of Small Business Legal Tips. I'm attorney Mark Bross of Bross LLC. Today we're going to talk about 5 common legal myths that small business owners believe and that end up costing them a lot of time, money, headache, and grief. In this video, I'll go through each of the 5 myths, why they're wrong, and how you can avoid them and protect yourself and your business. And please, if you'd like to get more helpful tips from us, please hit the subscribe button below and ring the bell to get notifications. Now, before we get into the details, I need to go through some boring formal stuff and get it out of the way. And although I am an attorney, I am not your attorney. So stuff I talk about in this video is not a substitute for legal advice. And if you need help with any legal situation, you should consult with an attorney located in your state. If you're located in Massachusetts and would like to book an appointment with me, I'm happy to speak with you. I will add links below to contact me through my website, www.brosslawllc.com. So now that we've got the boring stuff out of the way, let's get to it. First myth, I don't need a lawyer. I can just use templates online. Look, I totally get this myth. Templates are everywhere online, and they're quick, easy, and cheap. And this was before ChatGPT. All these tools make it very easy to create your own contract or download a contract and use it for free. And when you're just starting up, this seems like the path of least resistance and the easiest way to go forward. But here's the problem. Generic templates online or generated by ChatGPT rarely fit your actual business needs or protect your business how you want to. Often the generic business agreements they leave loopholes, they have vague terms and conditions, or they have requirements that you don't want to meet in your business. I met a business owner at a party one time who told me a story of how he was owed over $10,000 from a client for a breach of contract, but he was unable to sue on the contract because it required him to bring a lawsuit in California. And the ridiculous thing is that this was his contract. And so the problem was this was a Massachusetts-based business, but he had downloaded the contract from the internet, and the internet had what's called a choice of law or choice of forum clause that required him to bring the lawsuit in California. And the problem for him, which made the problem worse, apparently, was that the client was actually located in California. So that made the choice of law and choice of forum provision not all that unreasonable. And so if he wanted to sue on it, apparently, he had to go bring the lawsuit in California. But as I mentioned, this is a Massachusetts-based business, and he really didn't want to go to hire a lawyer in California and go sue him there. Because the reality is that a lawsuit, given the cost of going back and forth, hiring an attorney in California and everything else, you'd end up spending far more than $10,000 in the contract. So as a result, he decided not to sue on the contract. But this is real money for him. He was out to $10,000. The client breached the agreement, apparently, and owed him $10,000 under the contract. But he just decided that it was not worth it for him, or end up being a lost money for him, if he went and sued in California. So he decided not to do it. Now, don't let this be you. Contracts you download online or ChatGPT generate can be wrong and not fit what you want for your business. You don't necessarily want to use them, or at least you don't want to use them without having an attorney look at them. So recognize that ChatGPT, it's well known for creating what's called hallucinations, which means it generates things that are false. And I've noticed this myself, where I've asked it legal questions in particular, and it's notoriously wrong. Things that I know to be false. And so you can't necessarily rely on what's generated by ChatGPT, and you certainly can't rely on something that's downloaded from the internet without having a lawyer review it. The best contract for your business is going to be one that's crafted particular to your business by a lawyer. But if you don't want to use a lawyer, or if you can't afford a lawyer, the second best option is to use whatever template you have online, have it reviewed by a lawyer who understands your business and can let you know whether or not it fits what your business is and what you want to do. So that's the first myth. I don't need a lawyer. I can just use online template. Totally false. Myth number 2, forming an LLC or a corporation protects me from everything. I can't tell you how many times I've heard this one. And again, it's completely false. So an LLC or a corporation are great entities. And one of the reasons that people set them up is to try and shield their personal assets from the liabilities and debts of the business. So let's suppose, for example, this is totally made up. You had a small company, and let's just call it Coco Co. After my dog Coco, and we'll call it. It doesn't really matter if we call it an Inc. or an LLC. It doesn't matter either way. Whatever makes you feel better. It's a business that sells dog toys, dog food, provides dog walking, and dog training. Again, he's my dog, so I'm creating a business for him to get him things that he'd want. We probably need some training too, so we should make training as part of the business. But anyways, but let's suppose you set up this business to do this, Coco Co, to do this for you. And let's also suppose that you had personal assets like a house or investment bank accounts. It's for in excess of $1 million. And so the idea is that if you run the business through Coco Co, whether it be Coco Co LLC or Coco Co Inc., the idea is that if you run the business through those entities, you protect your personal assets from anything associated with the business. So that if Coco Co LLC owes money on a contract, Coco Co has to pay the money and they can't come after your personal assets. And that's the idea. And it usually works so long as you properly maintain everything and you follow what I call the rules of the form are. And so the rules of the form are just that every entity has certain rules that need to be followed in order to operate the entity and set it up and run it properly. For example, if you're a corporation, you have to have what are called articles of incorporation or organization, and you have to have bylaws. You have to have shareholders, directors. You have to have annual meetings with shareholders and directors. You have to have officers. Uh, all of these things all have to be followed if you're going to be a corporation. And this is one of the reasons why people don't do it. It's because there's a lot of rules to follow if you want to properly maintain the corporation. And the corporation only protects your personal assets if you follow those rules, or at least that's one of the things you want to consider. LLCs also have rules, and so, but a lot less rules. So for LLC, you've got to have a certificate of organization. You have to file your annual reports. You ideally should have an operating agreement, although not technically required, and a few other similar rules that you just want to follow. Generally speaking, if you follow the rules of the form for your entity, then you should be okay, and your personal assets will be shielded from the debts and liabilities associated with the business. So I think that's what people mean when they say forming an LLC or corporation protect me from everything. But, and this is a big but, there are times when this doesn't work, and your personal assets are still at risk, even though you're running a business through a corporation or LLC. And here are a few common situations where it can happen. First situation is if you commingle assets. Now, when I mean commingle assets, what I mean is that you use business income to pay for personal expenses, or you use business assets to pay for personal expenses, or you use personal income to pay for business expenses. Like, say, you put certain expenses on your personal credit card when they use another business expenses, or you put personal expenses on your business credit card, or things like that. Or anytime you use personal assets to pay for business stuff, then you're intermingling. Or anytime you use business assets to pay for personal stuff, you're intermingling. So you and look, every small business does it. So like everyone knows you do it. Like it's no surprise that they do it. But the more you do it, the more you're putting your personal assets at risk. So that's one circumstance. If you commingle assets and you do it a lot, your personal assets are still at risk, even though you're running through a corporation or an LLC. Another circumstance where your personal assets might still be at risk is if you commit a tort in connection with the business. A tort is a legal wrong where your actions cause harm or injury to another person. And this can happen even though you're acting in connection with the business. But if you commit a tort in connection with the business, your legal actions and they cause harm, your personal assets can still be on the hook. So, for example, let's suppose as part of Coco Co, you go into someone's house to dog sit or to watch their home, to take care of their dog while you're doing it. Now, when you're doing that, you think, well, I kind of like some of this stuff, so I'll steal some of it. Maybe I want it for myself. Now, that is a crime. It could send you to jail, of course, but it's also a tort called conversion, which means you're taking personal assets for your. So you are personally committing a tort in connection with the business, so you can still personally be on the hook, even though you have an LLC or a corporation running the business. So those entities don't protect you in those situations. Another common situation where your personal assets are still potentially on the hook occurs with banks or landlords. So often, when a bank loans you money, loans the business money, it's not uncommon for the bank to require a personal guarantee from the owner of the business, which means that the owners of the business personal assets are still on the hook. Landlords also do the same thing. So if you sign a commercial lease in Massachusetts, it's fairly common for the commercial landlord to require the owner of the business, especially a new small business, to also have to sign a personal guarantee, which again means that if the business doesn't pay, you personally are on the hook. So your personal assets are still on the hook. And finally, another common situation in Massachusetts is that there are certain statutes that still put the owner of the business who works in the business on the hook. So the most common one in Massachusetts is a violation of the Wage Act. If you're the president of Coco Co. and Coco LLC, don't care which one, and Coco Co. does not pay its employees properly, they can sue you personally for damages and your personal assets at risk. And that can be substantial. So under the Wage Act, the damages you could potentially owe are 3 times the wages that are owed to them plus attorney's fees. So again, it's another time where your entity does not protect your personal assets. Now, before I move on to the next myth, if you're finding this information helpful or entertaining, please hit the like button and subscribe button so that you don't miss the next episode. This channel is all about giving business owners and entrepreneurs the tools they need to succeed without getting buried in legal or financial mess. So if you like what you're receiving, please hit the subscribe button and the like button. Let's move on to the next legal myth, which is that verbal agreements are just as good as written agreements. Now, this one's a little bit harmful, and particularly harmful and tricky because it has a little bit of grain of truth to it. So technically, many verbal agreements can be legally binding, except in some circumstances. But this is very important. They are never, never, never as good as a written agreement. And if I could stick on more evers, I would. They are never as good as a written agreement under any circumstance. A classic example of this is from the movie Jerry Maguire. Do you remember the scene where Jerry shows up where Jerry, played by Tom Cruise, shows up to Cushman's house and is sitting across from Cushman's dad, who's played by Beau Bridges, who says, "You know I don't do contracts, but what you do have is my word, and it is stronger than oak." And they shake hands. Very powerful moment. And when he made that statement, Jerry was like so relieved because Jerry's business was basically on the ropes and it wasn't clear he was going to survive. And so he was hiring Jerry to be his son's sport agent. And so Jerry was like thrilled. He gave him a hug, and Cushman's dad was like, whatever. But it was a very powerful moment. But you all know what happened. Cushman's dad reneged as soon as he got a chance, and he signed a written contract with Bob Sugar, who was played by Jay Moore, who was Jerry's arch enemy. And when Jerry found out, he knew that he was done. And he knew that Cushman would no longer be his client. And also, he didn't sue him for anything. And the reason why is because the written contract that was signed with Bob Sugar was much better. It was a better agreement than the oral agreement that Jerry had. So the written agreement probably had all sorts of clauses that would prevent anyone from breaking it. Like, for example, there was probably an exclusivity requirement. There was probably a limitation of liability. There was also a damages clause that specified if you breach the contract, you owe me this. Probably all sorts of other that made it so that the contract couldn't be broken, or at least couldn't be broken without a significant financial penalty. And when Jerry found out about that, he knew that he was done. And so, because he knew that his handshake deal, even if it was enforceable, it could be broken at any time. Because there was nothing in there that said it had to last forever, how long, or what happens if there was a breach. Oral contracts are very difficult to enforce, and they don't have all the provisions in there that you'd want in a contract to make sure your business is protected. So don't make the same mistake that Jerry Maguire made. If it's important to your business, make sure the contract is in writing. It's the only way to ensure that your business gets what it needs and is protected from a breach of the contract. Legal myth number 4. I don't need legal help until I get sued. I know lots of business owners who believe that because I often get a lot of calls from clients who've never had a legal attorney until they actually get sued. And unfortunately, many of the problems that they're sued on could have been prevented if they had hired an attorney beforehand. This myth is clearly false. And by believing it, you're putting your business at risk. Waiting for a lawsuit to hire a lawyer is like waiting for a fire to burn your home before you get fire insurance. It's just too late. There are many problems that easily could be prevented by hiring a lawyer beforehand, and it is invariably far cheaper to hire a lawyer beforehand to make sure you're protected than it is to hire a lawyer afterwards when you've been sued. So don't wait for the problems to arise, be proactive, and make sure you're doing it correctly. The next myth, having a website means I own everything on it. Now, I get this one too. Business owners who sort of think that they own the logo on their website or the content that's been created for them in a blog post because they're the one who hired the freelancer to create it for them and they're the one who paid the freelancer to do it. And so they think that because I paid you, then that means I owe what you just produced for me. But here's the thing. It's not true that simply because you have paid them that you own it, unless there's some kind of written agreement to back it up. Simply paying someone for what's created doesn't necessarily transfer the intellectual property ownership to you unless there's an written agreement that says that. So without these type of agreements, you're not the owner, you're not necessarily the owner of everything that's on your website. And so to avoid any potential problem in the future, make sure that you have a written agreement that spells out exactly who owns what with respect to any intellectual property on your website or in any other area. Owner who believed any of these myths. But if you did, you can now take steps to do it. You should do it now before it becomes more costly in the long run. If you have any questions, please drop them in the comments below. And if you're finding this information helpful, please hit the subscribe button, hit the bell so you can get notified when the next episode is posted. Thanks for watching, and I'll see you in the next video.